business with the Appellate Division draw near, give your attendance, and ye shall be heard. Please be seated.
Good afternoon. Welcome to the Appellate Division First Department. I hope you had a relaxing and enjoyable and restorative summer and are ready to get back to arguing appeals. It's tradition of this court for a colleague to deliver remarks at the first sitting of a new presiding justice. And although this feels a little awkward for me to introduce a jurist to then speak about me, I am honored to introduce the honorable and esteemed colleague, Justice Peter Moulton, to address you.
This is an historic day at the Appellate Division First Department because Justice Renwick is hearing arguments for the first time as the court's presiding justice. She is only the second woman to head this court, almost 25 years after it was led by the amazing and indefatigable Betty Weinberg Ellerin. Justice Renwick is the first woman of color to head any of our courts, any of our four appellate divisions in this state. In 2008, she was the first African-American woman to ever be appointed to this court, and we are lucky to have her. Justice Renwick embodies everything that we need in a judge. She is whip smart, hardworking, fair, compassionate. Her approach to the law is grounded in an abiding sense of justice, honed, I have no doubt, by her years as a criminal defense lawyer for indigent people in New York City. She is the child of two hardworking immigrants. Her father, Septimus, was a carpenter and worked in construction. Her mother, Everil, worked as a seamstress and hospital aide. They instilled in Justice Renwick a work ethic that took her to Cornell as an undergrad and at the Cardozo School of Law. I should note here that we have two daughters of Cardozo Law on the bench today, Justice Renwick and Justice Kennedy. Speaking of Justice Cardozo, Justice Renwick understands the adage of that eminent jurist that, quote, the final cause of law is the welfare of society. She has lived by that credo as a housing court judge, a civil court judge, a Supreme Court justice, and an associate justice of this court, and she will continue to do so as our presiding justice. Justice Renwick cares deeply for this institution. She has been a visionary head of our court's anti-bias committee. In that capacity, she's made sure that all employees of this court feel respected and listened to. She has also initiated a project to interrogate and add to our historic courthouse's art and decoration. Art and decoration that is beautiful, yes, but a product of a less inclusive vision of justice and a product of the aesthetics of the late 19th century that often erased the contributions, indeed even the existence, of non-white people in this nation's history. Thanks to Justice Acosta's years of leadership, she is inheriting a court that is on firm ground. I have no doubt that during her tenure, we will continue to see that this court sustains and builds on its reputation as one of the preeminent appellate courts in the nation. Before we begin our arguments today, let us give our new presiding justice a round of applause.
Thank you. Thank you. Thank you, Justice Moulton, for those thoughtful and generous remarks. I promise to be brief, as we have important business to get to, but I must share with you all that it is my distinct honor and great privilege to serve in this important role of presiding justice of the Appellate Division First Department. I'm humbled by your presence, all of you. I recognize the significance of being the first woman of color to be appointed presiding justice of any appellate division, and only the second woman, as Judge Moulton alluded, after the Honorable Betty Weinberg Ellerin, to lead the First Department since its inception in 1894. Excuse me. It is not lost on me that when the court was created, Black men had been accorded the right to vote only 24 years earlier, and it would still be 26 years before women were granted the same right. It is an understatement to say that I am grateful to my community of supporters and to all of the remarkable women and men who have paved the way for my appointment and upon whose shoulders I stand. I thank them all. I am extraordinarily grateful to Governor Hochul for the opportunity to lead one of the preeminent intermediary appellate courts in the country. We are privileged to have the opportunity to deliberate over some of the most interesting and complex issues in a number of different areas of the law. For over 15 years, it has been my absolute pleasure to work with everyone in this great institution, particularly with my colleagues on the bench, including those who have retired and those who have joined our ranks in recent years. I know that in the position of presiding justice, I am only as good as the justices and the staff whom I lead. I am fortunate to work with justices who possess a strong work ethic and a desire to seek justice in every case. We also have a team of lawyers at the First Department who are among some of the smartest people whom I've had the privilege to work. The justices, with their support, the support of the lawyers, make the Appellate Division First Department the well-regarded court that it is. Additionally, our outstanding clerks, court officers, analysts, engineers, and custodians give their all every day to support us and the work of the court. I look forward to doing my very best to lead this court with distinction as presiding justice as we seek to fairly and efficiently adjudicate all matters that come before us. I thank you so very much, and thank you for your presence here. It really is a bit overwhelming, but I am so grateful. I'm filled with gratitude this afternoon. Thank you for your support, all of you. Thank you. Thank you. Thank you. And on that note, let's get down to business. We have a calendar to call. Thank you so much. First case is People versus James Bulwer. People versus James Bulwer, submitted. Federal National versus Adago. You're the respondent. Is the appellant here? The appellant isn't here, counsel. Do you want to argue?
Just briefly, Your Honor.
I'll give you 2 minutes.
2 minutes is fine. Thank you, Your Honor.
Submission and 2 minutes. Gabriel A. versus Ifoma A. is submitted. Stora versus New York City Board of Elections is submitted. Melendez versus Perlberger. Again, you're the respondent. There's no appellant. Do you want to argue? Submission and 2 minutes. People versus Jerome Dawson. Submitted. Kafisi versus L&L Holding Company.
Respond in 5 minutes, please.
And you represent third party, you represent which? National, thank you. Travelers Indemnity versus Fishback.
Good afternoon, Your Honor. Petitioner Appellant. Your Honor, my name is Don Puglisi from the law firm of Hush Blackwell. And if you would permit me, I'd like to introduce Scott Davis, who will be arguing the motion. He's been admitted pro hac into the court.
And you are from where, sir?
I'm from Dallas, Texas.
Dallas, Texas. Well, we like to say, one of our retired judges, that we have thousands of well-qualified attorneys right here in New York. And you had to go to Dallas, Texas to find one. But we welcome everyone, so you are welcome. How much time would you like, sir?
Thank you, Judge. I've had the opportunity of appearing in this court before, and I'm grateful for the opportunity to do so again, particularly on such a historic occasion. And I'll take as much time as I may be permitted of the 15 that
I'll give you 10. Do you wish for rebuttal? Sorry, do you, sir? Do you wish for rebuttal?
Yes, I would. I'd like to reserve 1 minute.
Okay, so I'll give you 9 and 1. 10. 9, 1, and 10. Bianca C. versus Alan D. Submitted. Dong versus Ho. Okay, do you wish to argue? You don't have to. It's sort of arguing against yourself, but you don't have to. A submission? Okay, submitted. Thank you. Piedra versus 111 West 57th Street.
Good afternoon, Your Honors, and congratulations.
Thank you.
Tracy Frankel for the defense appellants, and we wish to have 5 minutes and then reserve 2.
Okay. 5, and do you need the 5 and 2? Do you still want the 5 and 2? Okay, we'll see how it goes. 5, 2, and 3. People versus Carl Swift. Submitted. 549 LLC versus Luna. Okay, submission in 2 minutes. Zayed versus New York City Department of Design. Did you want rebuttal? So 8 and 2. And you asked for? 8, 2, and 10. People versus Barry Amadou? Submitted. Kanayama versus Kisi LLC?
Defendant, appellate, Your Honor.
I don't see a respondent.
2 minutes, Judge.
2 and a submission. People versus Rashid? Submitted. Lacona Rubio versus COA 200 East 34th is submitted. Gunsberger versus Fernandez is submitted. So the first case for argument is Federal National versus Adago. Justice Moulton is recused on this case. You may proceed.
Good afternoon, Justice of the First Department. May it please the Court. Thomas Segarelli from McCalla, Raymer, Lieber, Pierce, attorneys for the plaintiff respondent. This is a foreclosure case wherein the appellant appeals a grant of summary judgment to the respondent. Despite raising several affirmative defenses in their answer, the appeal centers around one specific affirmative defense, the issue of the 30-day notice. So it's plaintiff's position, or rather respondent's position, that all the other affirmative defenses are to be considered abandoned, which leads me to my primary argument here today, Justices. It's respondent's position that taking aside the issue of the zip code of on the mailing of the 30-day notice and the affidavit, the 1304 notice, the RPAPL 1304 notice, the RPAPL 1304 notice, which was mailed, can also serve as the 30-day notice, and that is pursuant to the Caracano case, which is cited in our brief. And because the appellant does not challenge the 1304 issue in this appeal, this court must affirm the issuance of summary judgment. Furthermore, the RPAPL 1304 notice, to set aside any sort of argument in regards to separate envelopes, the 1304 notice was not required to have been sent in this case due to it not being a home loan, and thus another reason why the court should affirm summary judgment. Plaintiff respondent rests on its briefs at this point.
Are there any questions?
I have one question. In the notice, did your 1304 notice state what is required in the 90-day default notice that you have, if you don't cure, that the loan will be accelerated?
It's our position that the 1304 notice, which contains the statutory requisite language, is sufficient to satisfy the 30-day notice.
I know that's your position, but I read the note and the mortgage, the mortgage contractually, aside from your requirements under the statute, you have a contractual requirement to send a notice that says, if you don't pay in this period of time, you have this grace period, and if you don't pay, we may accelerate the loan. My question to you again is, does the 1304 notice have that contractually obligated language?
It provides a 90-day period, not a 30-day period.
Does it say anything about acceleration of the loan?
It doesn't specifically say acceleration of the loan. It just specifically says that, you know, it could result in a lawsuit being brought against you. It doesn't necessarily say the words acceleration.
Okay, thank you.
Thank you, Your Honors. Any further questions?
No, thank you.
Thank you, Judge. Have a great day.
You too. Melendez versus Perlberger.
Good afternoon. If it may please the court, I'm Matthew Smith.
Just one moment, just wait for Justice Moulton to return. Okay.
Thank you, Judge. Good afternoon. My name is Matthew Smith. I'm an attorney with the law firm of Callan and Smith, and we represent the defendant respondents in this case, Carol Perlberger and Ralph Perlberger. This matter stems from a September 12th, 2016 automobile accident involving a pedestrian in Manhattan. The pedestrian is alleged to have walked out between two parked cars into the side of our client's vehicle as she was passing down a thoroughfare operating a vehicle. Essentially, the plaintiff passed away prior to this.
We know the facts.
Judge, at this time, it's our position that the decision of Judge Klein on August 22nd, 2022 was intimately correct. His decision was based on the implementation of the dead man statute under CPLR 4519. It was correct in that the only admissible piece of evidence other than our client's statement was the only admissible piece of evidence.
Sir, is there any tension between your position and the Court of Appeals decision in Phillips?
I don't believe so, Judge.
Okay, even though the court there observed that by its terms, 4519 only applies at trial or hearing and not to pretrial procedures?
Judge, there is some case law that states in a case where you have a decedent, it's usually used in wrongful death cases. If there's no other evidence other than that piece of material, no other tangible evidence, documentary, video, anything of that sort, then the dead man's rule would apply. And in this case, there is nothing else. There's no video, there's no either eyewitnesses, it's only Ms. Perlberger.
Anything else? Thank you.
Okay, thank you, Judge. Appreciate it.
Kafisi versus L&L Holding.
I didn't say earlier, I apologize.
Just a minute.
Sorry. Can I do 5 and 2 instead of 7?
5 and 2.
Good afternoon, Your Honors, and may it please the court. My name is Arthur Tergeson, and I represent third-party defendant National Acoustics in this matter, appealing a grant of summary judgment to to respondent on Labor Law 240. Candidly, respondent wrote a good brief, and if all you did was look at each argument by itself, we might not be here today.
So why don't you tell us, get right to the point, we know the facts, why it was inappropriate then for the plaintiff to be granted partial summary judgment here?
Your Honor, in this unwitnessed accident, if you look at if you look at the pieces at this case, it was an unwitnessed accident, and we know
Well, that doesn't matter.
correct,
It was
Your Honor.
unwitnessed. Okay.
Correct, Your Honor. But in addition to the fact that it was an unwitnessed accident, we have an incident report that states that he stepped off of the scaffold and slipped on debris. It doesn't say anything about a scaffold shaking. We have a medical record from the very next day that states that he slipped on debris getting off of the scaffold. Again, it says nothing about the scaffold shaking.
So the document you're talking about, the accident report or the incident report that you refer to, is replete with hearsay. It's one person who's told another person who's told another person. And then I think there are 3 different medical reports, but the entry that you referred to is not relevant to treatment. So that would not be introduced. I think the entry that is permitted and the other documents are consistent in that the plaintiff testifies the scaffold moved and then he slipped afterwards on that metal strip or whatever it was that was underneath the scaffold.
Yes, Your Honor. I believe the incident report. I believe the medical records don't mention the scaffold shaking. And while Justice Bluth did find that the records could be consistent with plaintiff's story, and that yes, she testified. Justice Bluth wrote that this began with the scaffold shaking. It is our position that the evidence indicates that that's not how plaintiff originally said this story happened, and we believe it is for the jury to decide whether the accident report and the medical records are consistent with the scaffold actually shaking. And as far as Your Honor's point that the incident report has hearsay, it is our position that the case law holds that as long as it's not the only piece of evidence in opposition to summary judgment, hearsay can be considered an opposition.
But what's the other admissible evidence?
It was the medical record that you had cited earlier. And then the other evidence we have is that National's witness, who was the foreman on the project, testified that the following day, when they learned about the incident, they checked every single scaffold they had on site. They checked.
That was after the fact.
Correct, Your Honor.
So anybody could have touched it afterwards. The question is whether it happened, they tested it before or at the time. No one was there, so that didn't happen.
Yes, Your Honor. Plaintiff testified that he inspected the scaffold each time he used it that day, and that there was never any issues with the scaffold.
Correct, but he said he checked the wheels. That's the locking mechanism or whatever else there was.
Correct, Your Honor. And the fact that plaintiff used the scaffold throughout the day without any incident. And while we
Wait, let me just, I have to ask you again. The plaintiff testified, this is how this happened. The Baker scaffold shook, and I fell. And then when I fell, I slipped on the stuff on the pieces on the ground. What evidence do you have to contradict that?
Your Honor, the evidence, it's not that we're offering the evidence contradicting that. It's
well, then how is there an issue of fact?
Sorry,
There's no issue of fact unless you say that something contradicts that testimony.
I misspoke, Your Honor. The issue of fact we're raising here is whether plaintiff's testimony should be believed in light of the fact that he tested it beforehand and it had no issue with it, that every single scaffold on site was looked at the following day, and the medical records...
But I already said that what was looked at after the fact is irrelevant, that it was tested after the fact is irrelevant.
Okay, Your Honor. Yes, Your Honor. Then looking at the medical records the following day where plaintiff mentioned nothing about the scaffold fall.
So that's what I'm having a hard time with. That doesn't, what the doctor said he said doesn't at all contradict what he testified to. He said, the scaffold shook, I fell, and then I slipped on the stuff that was on the floor. And the doctor says, the plaintiff says he slipped on the stuff on the floor. That's entirely consistent. So where is the contradiction?
Yes, Your Honor. It was appellant's position in this case that while that testimony may be consistent with that he ultimately slipped, due to the late nature of when he said he slipped, which was for the first time at his deposition, and I understand that there was boilerplate language in the complaint alleging that the scaffold shook. Appellant's position is that in this case, I see my time has ended, may I?
You can finish your sentence.
In this case, Your Honors, it really goes, we didn't come in here with blinders on. We understand how broadly 240 is read, how broadly 240 is read. But appellant's position is that if in this case, when it was, yes, it was unwitnessed, He didn't say anything about it shaking until his deposition. The medical records all just say he slipped. It's the same as the accident report, which, yes, has hearsay in it. At what point do we stop saying, okay, anyone can have an unwitnessed accident and be granted 240 with nothing but their word? At what point does a jury?
Okay, now you're going on for paragraphs, so I'll let you finish your rebuttal. Let's hear from opposing counsel.
Good afternoon, Your Honors. Jillian Rosen for the plaintiff respondent. Congratulations, Justice Renwick. It's
Thank you.
a terrific honor and an honor to be in front of you. We covered, I think the court covered a lot on appellant's argument. I'd like to point out 415.
Well, counsel is saying that the first time that the plaintiff said anything was a month later or something like that.
Well, the bill of particulars and the complaint alleges that the scaffold moved and it was insufficient to support him. And then I believe he's referring to when he notified someone. Yeah, he notified Mr. Lancaster the day that after the accident occurred. He said he fell. Then we don't have Mr. Lancaster because, as you know from the record, he was precluded from putting in an affidavit in opposition because he was nowhere to be found, despite plaintiff trying to depose him by subpoena. But I think what's really important here is that two things. Number one, at 415 of the record, it's undisputed, and plaintiff explains that falling off the scaffold is what caused him to contact the metal straps. It's clear that the ladder shook and it tilted towards him. He used his right hand to try to hold on.
And is there anything in the record, counsel, to raise an issue of fact as to whether that testimony is false?
No, in fact, if you look at 1688 of the record, which is the J.T. Magan accident report, what I think is really interesting is that the only person in this chain, so there's 4 layers of hearsay with Mr. Hackhav is another foreman for National. We have Lancaster, who's MIA, and then we have Mr. Hackhav. And Mr. Hackhav admits at 806 of the record that this information is based on 4 layers of hearsay. But let's go a step further, please.
If I may, because
sure.
I'm so glad you brought that up, because I have it right in front of me. Okay. And the bottom line is that it clearly says, that incident report that you're referring to, there was no statement at all from the injured party.
Correct.
And I believe her name was Imelda, am I correct about
That's
that?
correct, Your Honor.
Yeah, she didn't witness it, and all of the people that she interviewed also didn't witness the
That's correct. Not only did nobody, and there's no witness, Mr. Hackfag allegedly had a conversation with the plaintiff a week after the accident. And here's how Mr. Hackhav's testimony goes. First, he admits at 806 it's 4 layers of hearsay. Then, at 781 of the record, he actually admits that plaintiff told him that he fell. That's at 781 of the record. Then, later on in the deposition at 813 of the record, he actually admits he doesn't know how plaintiff was injured. He's not 100% sure what Mr. Kafisi told him on the phone because he didn't witness it. So we have Mr. Hackhav, who actually is the only other person besides Lancaster who has a conversation with plaintiff, and he testifies, I don't know how he fell, I don't remember what he said to me, but he told me that he fell. So not only, and okay, the one last thing before the light, because I do want to address the medical records. As we know under Mosquita, it has to be germane to diagnosis and treatment. It's not. But also, they have to connect, National has to connect Mr. Kafisi to the statements, and they do neither at 1708 and 1718. But I want to point you to 1718, because I think that's really interesting here. At 1718 of the record, I'm going to read what this says. While attempting to break his fall, he held his body weight with his right upper extremity, suffering significant injury to his right shoulder as well as his right hand and twisting the lower back. Well, this statement supports plaintiff's account. The ladder shook, tipped. I held onto the side with my right hand. I couldn't hold on any longer because I was afraid it was going to fall on me. I then fall to the ground, slip on the slippery straps, and hurt my back.
So your point is that that entry is consistent with what he has said
Correct.
the entire time, what
Correct.
plaintiff has said.
Yes, it is. If you have any further questions, I'll rest on my brief.
Thanks. Thank you.
Thank you very much.
Thank you.
Thank you, Your Honor. Just to address counsel's last point, I understand that respondent's belief is that that medical record is consistent with the idea that the scaffold shook and that he fell. National submits that the idea that he slipped on straps and went to go grab the ladder before he fell can also be read that he slipped on straps, and that's why he was grabbing the ladder before he fell. National submits that in this case, again, an unwitnessed accident, and again, we understand the law on that point, but with the medical records specifically only discussing that he slipped and no mention of the ladder, at what point does Labor Law 240 become too far? How is a defendant supposed to defend themselves when a plaintiff says, oh, I slipped?
Well, counsel, couldn't you have gotten Mr. Lancaster? He was your witness. He was your guy. And plaintiff testified, I told him what happened right away. So there are plenty of ways that you could have submitted or found information that you thought would actually contradict the plaintiff's unrebutted testimony, but you didn't.
If I may, Your Honor, yes, Mr. Lancaster worked for National Acoustics on the date of loss. Mr. Lancaster hasn't been with National Acoustics for some time.
But he could have written he could have written a report that day. This is what, I mean, there were plenty of ways that you could have submitted evidence to contradict plaintiff's unrebutted testimony. But none of what you submitted contradicts it. In fact, it's all consistent. It may not be as broad as you like it to be, right? But none of it is inconsistent.
Yes, Your Honor. To your point that Mr. Lancaster could have written something that day, the only reason he couldn't have written something that day was, again, because plaintiff never mentioned when the accident happened that the accident happened because...
I'm not sure that's accurate, because Justice Bluth actually noted in her decision that because he was the foreman, right, that he should have been one of the first persons that you deposed, and then the reasons that you gave were very vague. You didn't really set forth what efforts you made to locate him. I think that's more accurate about what happened here.
If I may, the foreperson, I think, has a supervisory position over the laborer. It was for the foreperson to instruct him as to what the rules were, whether you write a formal complaint or whatever. He went, he told him what was wrong. That was never said. And then no one ever got the foreman to write his own affidavit or to testify. So is it supposed to be the laborer who's supposed to know the rules at the work site?
Yes, Your Honor. On Mr. Lancaster's point, not only is he no longer employed, without going too far into going off the record, he hasn't exactly been the most cooperative person about any kind of...
Well, that's not the plaintiff's issue. It's not the plaintiff's problem, is it? Thank you. Thank you both.
Thank you, Your Honors.
Travelers Indemnity versus Fishback.
May it please the court. In construing the provisions of an insurance policy in a dispute such as this, a court must look to the actual language of the policy.
I'm going to ask you to put the microphone down just a bit more. You don't need to be right over it.
Is that better?
Well, it's not really better.
All right. How about that?
You continue. We'll see what happens.
In addition, a court construing an insurance policy must afford a fair meaning to all of the language employed by the parties in the contract and leave no provision without force and effect.
So why doesn't Keyspan control here?
In what respect, Judge? In regard to the other insurance provision?
Exactly, because the Avondale case, which is from the federal court, discusses the other insurance, but that predated Keyspan in a number of other cases.
In a number of ways, of course, Keyspan does control, but not in the respect to which Travelers has urged this court to find that it did, because the other insurance provision that was at issue in Keyspan did not contain the same language at issue here. And the Keyspan court, in its discussion
Aren't there crucial words during the policy period? Would you concede that?
I'm sorry?
The crucial words are during the policy period.
Those words,
concede that.
Those words are not present in the other insurance provision of this particular policy.
It was present in Keyspan.
It was, yes, in Keyspan. And in fact, in Keyspan, what the court specifically found was that the other insurance provisions clearly indicated an intent to apply to underlying policies, quote, in effect during the same policy period as the applicable excess policy. And the court further noted there the absence of any policy language suggesting a contrary intent. In other words, the court in Keyspan decided that case upon the language before it, consistent with its general processes that it described, which do control this court's decision. Noting the decision in Consolidated Edison, the court in Keyspan noted what I just said to begin my discussion, that you must look to the actual language of the policy, that they must be interpreted according to common speech and consistent with the reasonable expectation of the average insured, and further that surplusage is to be avoided. Applying those rules in Keyspan to the traditional other insurance clauses that were at issue there, the court came to the correct conclusion that those other insurance clauses did not apply in successive insurance periods. The court did not have occasion in Keyspan, and in fact, no court since Keyspan has had occasion, to determine whether or not other insurance clauses, which are worded differently, may have different scope and different effect. It is our position that here, this particular other insurance clause does, because what it says is if any insurer affording other insurance to the named insured denies primary liability under its policy, the company, meaning Travelers, will respond under this policy as though such other insurance were not available. In the Avondale case from the Southern District, which is the only reported decision in America that ever even considered language similar to this, the court found that that drop-down provision, as they described it, was an accommodation to the insured. Specifically, the Avondale court said that the effect of that language was that it obligated Travelers to temporarily cover its insured pending resolution of coverage disputes among the insurers. Applying the general interpretive principles outlined in Keyspan to this language would lead to the conclusion that at the very least there is some ambiguity in the policy language that would entitle us to conduct discovery or possibly to create an inference against the insured. That is more apparent if you consider the fact that this was an unusual policy. This is not a typical policy in so many different ways. But one of those ways is it was a policy program. There were master policies that we've referred to as the manuscript policies, dozens and dozens of other related policies issued in connection with this program, including what the parties have described as the form policies, which were issued for regulatory purposes in various jurisdictions that differed materially in several ways from the manuscript policies which served as the master policies. One of those material differences was in regard to the—
So, counsel, wait a second. You are saying that this policy doesn't say that that the insurance should be allocated on pro rata time on the risk?
That's correct. That's exactly what I'm saying.
Where does it say anything else but that in the policy? What language are you speaking of specifically?
First of all, it doesn't say at all what the
I
allocation
understand that,
method
but
should be.
Keyspan has basically said in these asbestos policies, in these asbestos cases, that's how we're going to interpret the language. So tell me, what language do you think negates that interpretation?
There's
Not just Keyspan, Con Ed, I mean, there's like 40. The Court of Appeals has heard this more than one time. So you're here with a full Court of Appeal panoply of cases.
in fact, the Court of Appeal.
You know, Keyspan was actually my case. I remember it very well. So tell me, what language are you saying that negates that interpretation of the policy?
There are three
Read it to me. Yeah.
I'm sorry. There are three aspects of the policy that I would refer
Tell
to.
me.
First is the language in the actual other insurance provision that I just quoted regarding the obligation of travelers.
Read the language to me, please, that you think negates that interpretation.
If any insurer doesn't limit itself in any way to valid and collectible insurance, applicable insurance, insurance on the same terms, et cetera, which
You're
is...
talking about if any insurer affording other insurance, is that?
That's correct.
So why don't you read the specific language that you're speaking of?
If any insurer affording other insurance to the named insured denies primary liability under its policy, the company will respond under this policy as though such other insurance were not available. That is in sharp contrast to the standard other insurance provision.
But how does that change the time on the risk pro rata allocation? That says nothing to that.
I would disagree.
Okay, so then what's your next language? Let's say we disagree on that.
That must be contrasted with the standard form language. of
Let's
the
say we
form policy.
disagree on that. I don't think that applies at all. But what's your next language?
Finally, I would point out that these policies contained, the manuscript policies contained endorsements that were an implicit recognition of the difference between the two other insurance clauses. We've cited it to you in our reply brief, and specifically what it did was for a particular project at two particular locations, the Morrison-Knudsen work at Prudhoe Bay.
I'm just really wanting you to focus on the language, not implicit. I'm saying, what language are you saying would change Keyspan's finding?
The language that I just cited
Okay,
earlier, read in
that's it?
conjunction, yes, read in
Okay.
conjunction and in contrast with the other insurance clause of the form policies, and further read in conjunction with the endorsement in the manuscript policy, but not the form policy, which omitted and deleted that other insurance provision, that language I just discussed, at a particular job site, and it did so in each of the manuscript policies, never in the form policies. It did so because it was an clear recognition that the risk associated with this other insurance clause was different than and greater than the standard form other insurance law language included in the form policies. The court failed to consider the overall architecture and structure of this program and the effect of those endorsements, and therefore rendered the language I quoted to you surplusage. Thank you.
Thank you.
Good afternoon. Stephen Gimliano for the Travelers Indemnity Company and the Travelers Indemnity Company of Connecticut, the plaintiffs' respondents.
So counsel, opposing counsel is saying essentially that the other insurance clause here is different than the other insurance clause, I believe is what he's saying, in Keyspan and the other cases. Do you agree with that?
Your Honor, we did not look to see what was in the Keyspan case. I know one member of the panel had that case in the trial court.
And of course, I'm speaking of the Court of Appeals case.
Right.
Correct, but Your Honor, we didn't see it. But Your Honor, there's a bunch of things. One is I think that the court and this whole inquiry and the analysis here starts and stays with Keyspan, and that's Court of Appeals 2018. Obviously, the Keyspan case.
And they refer in Keyspan to other insurance.
It did not. It didn't even address the issue. Your Honor, and there are reasons for that as well. The other insurance provisions, as the Court of Appeals found in Viking Pump 2016, and Chief Judge Kay wrote about in Con Ed 2002, other insurance provisions have nothing whatsoever to do with
The
successive or consecutive policies.
because they're
only with
talking about
concurrent.
periods where there is no insurance at all, although there's continued injury.
What other insurance provisions really have to do with cases that we see in this department all the time.
No, I'm saying Keyspan. Keyspan discusses only the periods where there is no insurance at all, but the
Actually,
injury continues.
Keyspan addressed a bunch of points, including successive insurance and how that should be allocated, and how you should treat periods where there is no insurance whatsoever. And that's what Keyspan said. Keyspan said pro rata time on the risk with allocation to the insured for unavailable or uninsured periods. That's very much what we have here. Other insurance provisions are typically designed for construction accident situations or construction defect situations where there may be multiple policies all applying to one
same
point in
period.
time. Exactly right. So you may have the owner with a policy, the general contractor with a policy,
So is it your position that the company is seeking insurance from you for a period of time when there is no insurance? But there's no insurance policy that you've issued?
There are points in time when there are policies, and what's before the court today is claims that arise out of the Johansson Company, which is 1980. I think January 2nd is when Fischbach bought or acquired Johansson. So it's from January 2, 1980 and beyond. Travelers has the policies without asbestos exclusions until partway through 1986. And then beyond there, I think the company that's an affiliate of Fischbach, actually, which is National Union, had the coverage for 3 years, and there are asbestos exclusions there, and then beyond, there's no available coverage.
Well, that's it, right? There's no available coverage.
There isn't after a point. That's absolutely right, Your Honor.
And so your position is Travelers isn't covered by that?
Our responsibility is pro rata and time on the risk what's allocated to our unexhausted policies. Anything else is the responsibility of Fischbach, which is in the papers, is an affiliate of the American International Group, one of the largest financial institutions, and we know it as AIG. Another thing about the other insurance provision, that was argued before Justice Gammerman in 2010-11 in the opposition that Fischbach filed to Travelers' motion for summary judgment. Fischbach argued that because of the other insurance provision, it shouldn't be pro rata. And Justice Gammerman's April 8th, 2011 decision and order rejected that and said, yeah, it should be pro rata allocation. He said, whether you allocate for unavailability, that's an issue for another day, and obviously Keyspan addressed that issue squarely, and that's what brings us here. As I mentioned, Con Ed, obviously, and Viking Pump, and there is no surplusage when it comes to the other insurance provision, because if Fischbach, a contractor, were on a job site somewhere and there were a sub of Fischbach's and there were an injury, then the other insurance, injury in a point in time, the other insurance provision in the traveler's policy that was implicated would operate. So it isn't as though we travelers are trying to read that out and say, you don't read the policy as a whole. You do read the policy as a whole, but the other insurance provision has a very specific application that we see in this department and throughout the state all the time. And Your Honors, if there is any doubt about what Justice Schechter did when she entertained our motions, there were 60 pages of briefing, 15 pages of affidavits and affirmations, 1,845 pages of exhibits, and the transcript spanned 46 pages. So it isn't as though she gave the back of the hand or was flippant or gave a cursory review and analysis. She really dug into this. She had to.
I hear everything you've said. I just want to make sure that you're addressing the arguments that have been made with regard to other insurance. Essentially, I think what you're saying is the other insurance that opposing counsel is referring to is really no different, substantially different than different other insurance clauses.
There isn't, and Your Honor, most important, there's no difference that plays into allocation of this type in any way whatsoever.
I just want to make sure that you've addressed that.
If the court wants to hear anything further about, for example, there's at least the argument in the papers about the 1990 settlement agreement which addressed retrospective premiums and was solely addressed to premiums under the various policies. And the releases were for premiums. It didn't address allocation in any way. Retrospective premiums play no part, zero, in the allocation of liability in any kind of case that I've ever been involved in. And I've been doing insurance coverage work, I think, since October of 1988. And it just isn't. Allocation is done blind to retros. And in this one, Your Honor, or Your Honors, I'm sorry, Fischbach and Travelers came to an understanding on retros. As I mentioned, it is absolutely, the releases are almost mirror image for the release of premiums. Fischbach also released Travelers for any claims that Fischbach might have in the future for return premiums or for premium credits. We heard when the question was raised at summary judgment, why wasn't this presented to Justice Gammerman if it really has some sway or some play in the allocation issues? Why wasn't that put in the papers or argued to Justice Gammerman in 2010 to 11? We heard from Fischbach that the lawyers didn't know about it, that Fischbach is a defunct company. I don't know what a defunct company is. I don't think that that's a defined term, so I don't know what that is. And besides, most importantly, AIG was involved in the run-up to and in the entry of and execution of the 1990 settlement agreement. Fischbach submitted below some exhibits, including the 1990 settlement agreement. So we don't have little Fischbach. What we have is AIG and Fischbach, represented by a firm, K. Scholler, Fearman, Hayes, and Handler, back when they were at 425 Park. And that agreement deals with retrospective premiums, which don't play into allocation anyway, but only for the release of premiums. That's what the document says, and that's what the entire run-up to it. But the document, it has an integration clause, and anybody can look at it.
Thank you.
Just respectfully, respondents requested the court affirm the trial court's September 15, 2022 order. Thank you.
Thank you.
Very quickly, first
I'm just going to say again, just push the microphone down a little bit. Yeah, I think not too much. Yeah, I think your voice will carry better that way. You don't have to speak.
Thank you. First, in regard to the question
Much
of
better.
the underlying release, the policy specifically defined premium to include incurred losses, which in turn was defined as actual paid losses, reserves as estimated by the company for unpaid losses, and allocated loss expense. This was a fronting policy. All the losses that Travelers paid, regardless of its source, it was able to recover, and it was entitled to receive an administrative and claims handling fee for doing so. It had every incentive to pay these losses. It released these claims in 1990, and at the very least, we should have been entitled to conduct discovery regarding the scope of the release. Second of all,
Regarding the scope of the 1990 release?
yes, the 1990 release released Travelers' right to recover actual paid losses, the reserves that it had included, and defense costs, which are allocated loss expenses. It specifically released those claims in exchange for the payment at the time in 1990 of $22 million, a number that would be well in excess of $50 million today. It didn't walk away with nothing. It had the right to recoup these losses if it chose as retrospective premium. And if I could, just one last point. What you were told regarding Judge Gammerman's earlier ruling was incorrect. There were two issues before the Judge Gammerman in the original lawsuit. One was whether or not this was an all sums or a pro rata allocation policy, and the second was the method of pro rata allocation. The judge did rule that it was a pro rata, but he specifically denied travelers' request for summary judgment that time on the risk be the method of allocation, and suggested instead, consistent with the rules in all of the cases we've discussed today, that the appropriate method to allocate the costs in the instant litigation is best determined after examination of the underlying policy particulars in this action. We do not believe Judge Schechter did an examination or proper consideration of those policy particulars. And if she had, she would at the very least have given us the opportunity to conduct discovery regarding these issues before entering summary judgment. Thank you.
Thank you. Thank you both. Piedra versus 111 West 57th Street.
Good afternoon, Your Honors. Tracy Frankel for the defendant's appellants. I first wanted to address that there are questions of fact and questions of credibility that both require the court to deny summary judgment to.
Counsel, did you raise the argument about the plaintiff giving inconsistent accounts of the accident below?
Well, credibility was raised in connection with his testimony with respect to the photographs.
Does it matter that you adopted the statement of material facts the plaintiff submitted?
Well, I would disagree that we adopted it because there were disputes of some of those statements of facts within the substance of the affirmation and opposition. And in addition, paragraph 4 of the affirmation and opposition said that for the facts, we are relying on the testimony and exhibits that are attached to the motion.
Did you put in an opposing statement of facts?
No.
So have you read the rule, right? If you say, yes, I agree, those are the facts, or you put in a statement, a short, concise statement of what facts you think are not correct, right? And you didn't do that, did you?
No, we didn't do that. And the rule certainly is, was promulgated to be helpful, to have easy access, but it is not determinative. It certainly is up to a judge's discretion as to how they want to enforce or not enforce that rule. And I would just...
So what did you specifically dispute? What about the plaintiff's testimony in your affidavit, or anybody's affidavit as opposed to attorney affirmation? What specifically did you raise below?
In the affirmation and opposition specifically, we raised the fact that the photographs that plaintiff was relying upon did not indicate that what was exhibited in those photographs was actually the wood upon which plaintiff fell, because we don't know when those photographs were taken. We don't even know by whom they were taken.
How did that
or when.
dispute the plaintiff's testimony?
So the plaintiff's testimony actually, in and of itself, was sufficient for the court to deny summary judgment.
Did you argue that below?
We didn't, but we do believe that on its face, the court had the information that it needed, including the sworn testimony of the plaintiff, to arrive at the decision that whatever affirmation and opposition was put in.
So again, what about plaintiff's affidavit or his deposition testimony are you claiming was insufficient?
Thank you. Okay. So the plaintiff did not know which of the pieces of wood in the photos was the one he stepped on. He said that in 208.
May I ask, what difference does it? He says he's coming down the stairs. There's wood. There's not supposed to be wood on the stairs, on the passageway to get down. There's wood on the stairs. He trips over the piece of wood, slips over, trips over the piece of wood. What difference does it make exactly which piece of wood it was?
Well, it's what is this wood really? There are 3 times in the
Is it, are the stairs wooden?
well, there are wood forms that are in the metal pan.
Are the
and so-
stairs, the
of the
stairs?
Yes. So the 3 times the defense counsel tried to get plaintiff to clarify whether what he was stepping on was a piece of wood that was meant to be part of the step or an excess piece of wood that was debris. The plaintiff,
But he said it was debris. He said it was a piece of wood.
those questions specifically were not answered. He kept just saying, I stepped on the wood. So
On a
it was
piece of
very
wood.
unclear.
On a piece of wood.
Well, you know what? I respectfully disagree because I looked at the deposition transcript, I looked at the photos, and plaintiff was quite clear about the fact that the photos showed the area where he fell and the pieces of wood. And there was some back and forth about what piece. And he said, listen, I don't know, but but one thing is very clear. Where he fell, that was depicted in the photo, and the pieces of wood that was still on the staircase. Photograph taken by some unknown coworker, either a day or after. But he was very clear on that.
Well, I believe that there's a credibility issue that a jury should review.
All right, well, what
in that
evidence
regard.
did you raise to, bring the credibility issue in question?
Well, I think it's raised within the plaintiff's own testimony. I think the fact that it was an unwitnessed accident, he didn't report the accident to
Plenty
anyone.
case law here in this court that says just because it's unwitnessed doesn't preclude summary judgment, particularly if there's no evidence contradicting what has taken place.
Well, it's that last piece, Your Honor, that we focused on in our briefs because as plaintiff was confronted at his deposition, there was an incident report wherein he reported that he looked back because he heard a noise and then he fell, and he didn't mention wood at all. And when plaintiff actually testified that he spoke to someone, I think a day after his accident, he also didn't mention wood. And so the fact that he's looking at photographs taken who knows when of pieces of wood on the stairs, is it really reasonable to think that the same piece of wood is there, especially on page 161 of the record when plaintiff had testified already that the wood had fallen after he slipped on it?
You have rebuttal. Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. My name is Michael Altman. I'm with the Altman Law Firm. We're appellate counsel for plaintiff respondent Mr. Piedra, and it's an honor to be here on such a historic occasion.
Thank you.
I think really this appeal should come down to page 802 of the record. Again, on the motion, defendants adopted the version of facts put forth by Mr. Piedra, and they have never challenged, and not on the motion, and really here, his description of how he fell. And that's why he got summary judgment, and he was awarded summary judgment, excuse me. And I'd like to touch on the issue of the rule pertaining to a counterstatement of material facts. There are cases saying that you don't put form over substance. Those cases deal where somebody puts in an affirmation in opposition and puts their facts in the opposition section of their affirmation and doesn't do a separate counterstatement of material facts.
Okay, but let me just ask you, counsel said, well, I submitted contradictory information or factual information, evidence, in an affidavit or an affirmation. I guess if it's an affirmation from an attorney, I guess that couldn't possibly be it. But in opposition, my question to you is, did you see any evidence that would contradict, not was it as full as it could have been in one area or another area, but did you see any information that the defendant submitted that would contradict the plaintiff's testimony? He was coming down the stairs, there was wood on the stairs, he slipped on the wood. Because That makes out his case. So I'm asking you, did you see anything that contradicted any of those three things?
Not at all, Your Honor. And with that, if there are no further questions, we'll rest. Thank you.
So, counsel, I'm going to ask you the same question.
Yes.
Regardless of whether you think his statement was fuller in one place or another place, did you submit any evidence that plaintiff's testimony, he was walking down the stairs, he slipped on the wood on the stairs and he fell? Anything that would contradict any of that?
When there is an unwitnessed accident only known to the plaintiff, the court looks to circumstantial evidence, not because it's impossible
Okay,
to
but
have
so
someone
what?
who was
So
present.
again, evidence. What evidence do you have that would contradict, not just surmise, or maybe it didn't happen that way? What did you submit? An affidavit? A document? What did you submit?
Well, the plaintiff's own testimony that with respect to not knowing necessarily which piece of wood it was or what step even he stepped on, that was enough to raise an issue of fact as to where and whether this accident happened the way he said. The fact that plaintiff did not raise wood as an issue or the accident issue for a month, and then only after he has someone take a picture of stairs with wood on it does he say, oh, this accident happened because of wood. I only also wanted to raise with 1.7E2 the fact that the court said this was a passageway because it was his sole access to the work area, but Mr. Rose had testified that there were 2 sets of steps for each, so I question whether the court had
steps
looked.
for each,
Egress.
okay, for
Of each
egress.
floor.
Okay.
Sorry about that. The court also said that 1.7E2 applies because
So
the
what
wood-
precluded him from using the steps he used?
Nothing, as far as we know. But nothing precluded him from using stairs that, if those were even dirty or
It doesn't
messy at
matter
the
if there
time,
was
would be
another set of steps. He used
court-
the steps that it was appropriate for him to use those steps.
The argument is based on the court's statement that this falls within 1.7E2 because it was his only access way, and that there is a question of fact. Additionally,
Isn't
the
it still
court
a
applied.
passageway?
I'm sorry, what?
Isn't it still a passageway under the industrial code?
It may be, and I'll concede that that wasn't analyzed in any of the papers, so.
But you just said
I
it.
won't argue it now.
Anyway, the red light's on.
Yeah,
Thank you. Why don't you
wrap
finish
it up? Okay, lastly, the court had based 1.7E2 on the fact that he slipped on wood, and that should be sufficient to fall under E2, except E2 is a tripping hazard, and the court already said that what he slipped on wasn't slippery, it was wood. So we find a question of fact as to whether 1.7E2 even applies here. Thank you.
Thank you. Thank you both. I-49 LLC versus Luna.
Good afternoon. May it please the court. My name is Tom Keene. It's my privilege to represent Mr. Ruben Luna in this case. And I want to say I was lucky enough to be here for the first all-female panel. And now I'm lucky to be, I don't come here as often as I'd like, but I got lucky twice. I want to say to you directly, Judge Renwick, that someday, hopefully far in the future, next generations will look up and see your name up there. I hope you're so proud of that.
Thank you very much.
That's terrific. Down to business, I want to say this. There have been 2 very recent cases, one June 29th of 23 from this court, a panel that you were on, Judge Moulton, 3350 BW 136. They're both cited in my brief. They're exactly the same case. The guarantor is sued. They can't, there's a good faith disagreement as to how much, if any, money is owed. And so you can't get 3213. 3213 is a no drama motion. No stories, no drama. There's a story here. The story is the landlord was supposed to file a C of O and he never did. So with that,
And these issues that you raised don't come out of the guarantee, they're applicable to the lease, not to the guarantee itself, but with abatements connected to the lease.
They are, but as the lower court pointed out in a 6-page decision, what we're talking about here goes to the heart of whether any money was owed at all. If no money is owed by anybody, then there's nothing to guarantee.
Exactly, the money owed under the lease,
I'm not picking.
right?
I
I said the money owed under the lease.
Yes, yes,
That's
the
the key.
obligations of the tenant under the lease. Thank you all. Enjoy your day.
Thank you. Zayed versus New York City Department of Design.
Good afternoon. Good afternoon, Your Honors. Roy Anderson from the law firm of Gardner and Bloom on behalf of the appellant, third-party defendant, Iron Bridge Constructors, Inc. We are appealing the lower court decision denying Iron Bridge's motion for summary judgment seeking to dismiss respondent Schiavone's third-party complaint.
So this is a case where the individual, the plaintiff, was hit by a gate, and there's a question of the injury itself and who may have been responsible for the dangerous condition, that is the swinging gate. And there's evidence in the record that one of the Iron Gate employees, who's no longer there, may have been the one who arrived early and was supposed to secure the gate. But where is the evidence of no negligence? What have you introduced to show that Iron Gate was free from all negligence, either with regard to securing the gate or with regard to work arising out of the contract?
Well, I believe the relevant law is that the only evidence in the record here is that Robert Marriott sometimes opened the gate in the past. There is absolutely no conflicting testimony that nobody knew if he opened the gate on the date of loss. More importantly, he's one of 10 or 12 people who had authority to open the gate. All of the subcontractors with trailers in that yard had keys and authority to open the gate.
So you haven't excluded the possibility that he was negligent in this, or that Iron Gate was?
Well, there's absolutely no evidence to show that he was negligent. The only evidence is inadmissible habit evidence about what he did in the past. There's no conflicting evidence that no one testified that he opened the gate on the date of loss, and more importantly, no one testified that he ever at any time opened and then failed to secure the gate. And most importantly, this is Schiavone's gate. Schiavone is the general contractor for this project. Brian Diffley, the project manager for Schiavone, testified that when they mobilized the site, he inspected the gate, he found it to be serviceable, so he put it into use and he installed some recycled stone or gravel within the swing radius of the gate. And so when the gate, as he testified, opens, it drags into that recycled stone. There's a photograph of the gate on page 498 of the record. And there you clearly see this recycled stone, which he testified is the same type of recycled stone that he installed in both yards and in the low spots in the yard. He tried to avoid conclusively testifying that he installed that recycled stone in that spot where the gate dragged into it, but he did admit that that might have been the case. More importantly, the person who inspected the gate and put it into use testified that there was no brace, there was no locking mechanism to actually secure the gate in the ground. And if you look at the photograph, that's clearly the case. There's no bar that goes up and down to go into a hole in the ground. There was only one witness, Carlos Herrera from Schiavone, who testified that there was a hole in the ground to secure the gate. Looking at the photograph, that clearly is not true. Instead, there's only very rudimentary means to secure it, as if you look at the photograph, there's a traffic cone or a piece of scrap wood that can be placed on the ground, at least in that photograph, in front of it. And again,
So can I ask you, the testimony is Marriott
was one of the persons who opened the gate in the morning, correct? There was testimony. Did you put in an affidavit for Marriott saying, I didn't open the gate that day?
Marriott was no longer employed by Iron Gate,
okay,
so
but the
we have
question
no
is-
ability. The answer is no.
You have a lot of ability. You have big subpoena power, right?
Right.
But
Well,
you didn't find your guy. So we have testimony in the record, circumstantial testimony, that your guy was one of the guys who opened up the gate every morning. And you didn't refute that testimony in the record, correct?
I would say that's not correct.
Well,
because
tell me what you put in to refute the testimony that on the day of the accident, Marriott didn't open up the gate.
I put in the record that that is inadmissible habit evidence about what he did in the past that is not admissible to prove what he did on the date of loss. That's black letter evidence law.
That's just poking holes in the plaintiff's motion. It's not coming forward with affirmative proof that Marriott was absolutely excluded from having any possibility of opening the gate that day. I mean, at trial, you've got plenty to work with, but I think on a motion for summary judgment, you have an issue of fact.
That's not poking holes in the plaintiff's claim. The plaintiff only.
Right, I'm sorry.
Schiavone.
Right.
I believe the case law we cited in our brief, a multitude of different cases that shows that evidence that a party could have done something is insufficient to defeat summary judgment.
If you prove that you didn't do it, right? It's not enough for you to say that the plaintiff or the movant didn't prove their case. You've got to prove your case first. So how did you prove that no one from Iron Gate opened the gate that morning? Did anyone put in any affidavit that said, I checked everyone who was here, no one opened the gate that morning? I checked our records, no one opened the gate that morning. Is there any evidence that you put in affirmatively showing your lack of evidence of negligence?
No, but I would say that based on prior decisions of this court, that's not necessary. The Vargas versus
You don't think you
Salamandre,
have to prove your prima facie?
not based on
How do you
Vargas.
prove your prima facie?
Based on Vargas versus Salamandre, I believe that case is pretty instructive. The worker was injured when he fell over a pile of materials at a construction site. There was evidence that RAD, the movement defendant, had created similar piles, but this court found that was irrelevant because there was no evidence in the record that RAD had created the pile that the plaintiff fell over. And even assuming Robert Marriott opened the gate and secured it in the method designed by Schiavone, that would be an incredibly expensive precedent to establish that merely opening a gate makes you the insurer for the entire yard.
Opening a gate that you don't close and hit somebody in the back? Opening the gate without closing it? You don't think that that is...
I opened the door to this building when I walked in here. I'm not.
But it closes on its own, so we're talking about something where the gate had to be secured, not something that secures itself automatically.
Secured in the manner that was designed by Schiavone. The only method for securing this gate is opening it. If you look at the photograph, there's no method to secure it. They claim that there's a hole in the ground. Brian Diffley, the person who designed or the person who inspected the gate, testified there was no hole in the ground.
So, sir, does your argument distill to third-party plaintiff won't be able to make a prima facie case at trial?
Yes, and I believe that's supported by the prior decisions of this court cited in my briefs.
But isn't that contrary to our procedural law that says regardless of who the movant is and what their burden is at trial, the movant, as Justice Moulton and Justice Scarpula mentioned, has to make a prima facie showing on the motion through evidence in admissible form, affirmatively establishing that party's position. So if it's a defendant, affirmatively establishing that the plaintiff, an element of the plaintiff's claim can't be demonstrated. The key word here is affirmative. So pointing to holes, as Justice Moulton said, or gaps in the third-party plaintiff's proof isn't enough for you to get summary judgment.
I believe that in the Vargas case it was, in the Mooney case it was, also several Second Department cases cited in my brief. Kimball Malone, also a very similar factual pattern, albeit not on a construction site, in the Portova versus Dynasty Meat Corp. That was there was blood and pieces of chicken bones and et cetera on a sidewalk in front of a grocery store. And even in that case, the second department held that that was not sufficient to defeat a summary judgment motion of the supermarket.
Thank you.
Thank you.
Good afternoon, Your Honors. Matthew Lavoie of Newman Myers for the respondent, Chivone Construction.
So, counsel, would you tell us what evidence you have that you've raised issues with regard to challenging the summary judgment?
Well, Your Honor, as Your Honor stated, it is the appellant's burden in this case, as they were the movant, and as the lower court found that they didn't establish they're entitled to summary judgment because they did not affirmatively establish that they did not create the condition.
What do you? My question is, what do you have to counter what counsel says that it was not? There's no evidence that Iron Gate is free from evidence, free from negligence. He's saying that no, they're not negligent because they didn't. There was no means to secure the gate. There's also the issue is arising out of the work. He says there's no negligence as far as that's concerned. What do you have to counter what he's saying on those?
Yes, Your Honor. So a few things. First, counsel mischaracterizes Brian Diffley's testimony. He didn't state that there was no locking mechanism. Instead, he stated that he didn't recall was his testimony. As for the photos, you can't discern from those grainy photos if there was a locking mechanism, as Chivone testified that there was. And as Your Honors bring up, there is evidence that appellant's foreperson every day went through that gate, opened it up, he had keys for it, he had authority to open it up. So there's an issue of fact as to who did it. And for that reason, it's similar to two other First Department cases cited to in our brief, Armental and Quigley, and I might add, Your Honor, Justice Renwick was on the panel for both of those cases where plaintiffs stepped on a pile of unsecured pipes. In Armental, testimony established that multiple defendant corporations used black pipes on the site. So there's an issue of fact as to particularly which one left that pile on the floor. And in Quigley, this court said that the evidence did not establish who left the pipes in front of the shanty, just as here, the evidence doesn't conclusively.
Did you put in an affidavit from your guy who opened up the gate every day saying, I didn't open up the gate that day?
For Chivone? No, no one knows really conclusively who did it on the date of the accident, and as the movement, it was appellant's obligation to do so.
Right, but you have control of your guy, and you know whether your guy did it or not, right?
Well, our guy, I believe, testified, and he didn't know whether he did it on that particular day. I think none of the deponents knew for sure, and for that reason, there's an issue of fact.
I mean, they knew they didn't do it, but they didn't know who did it.
My memory isn't that exact, but I don't know if anyone said I didn't do it, but certainly no one knew who did it. There's no testimony from appellant's foreman or any affidavit, as Your Honor stated.
So how are you going to meet your affirmative burden?
Your Honor, we were not the movement.
No, I mean at trial. I'm just curious. How are you going to meet your... I understand this is a summary judgment motion, but what are you going to do on how are you going to meet your affirmative burden on...
I'm not sure, but I would submit...
You're leaving it for another day, huh?
I'd submit to this court that that's not up for issue, for discussion today, I suppose.
You're asking him to reveal his trial strategy.
Further, briefly about the Vargas case that counsel mentioned. It's true that the defendant, a bricklayer, Rad, was granted summary judgment because there was no evidence in that case connecting it to the pile at issue. However, there were two other defendants where there was evidence connecting them to the pile. It was a concrete supplier and a concrete contractor, and summary judgment was denied to those defendants. Just as here, there's evidence connecting appellant's foreperson to the gate. In fact,
Sorry, there's a giant bug here.
It's a lantern bug.
It's a little
so
distracting.
It's literally a lantern bug, and we're required to kill it.
We are. And there's
Justice
no
Scarpullo told me
vegetation here. That's pretty interesting.
Right. Anyway.
Of course. In the Vargas case, appellant mentioned that one of the defendants was granted summary judgment in that case was because there was no evidence tying that defendant to the specific harm. But there were two other defendants that summary judgment was denied to because there was some evidence tying them to it. Just as here, there was multiple people testifying that their foreperson opened the gate every day.
If I may, I want to go back to the evidence because there was a east gate and a west gate, right? I believe. Well, you know what? Let's move away from the direction, but let's just stick with the fact that on the day of the accident, Marriott was already in the trailer.
Correct.
And plaintiff was going to visit him, and when he was leaving, that's when the accident happened.
That's correct. And plaintiff's duty every day is to, after checking in his own trailer, he goes through the gate to appellant's trailer. He noticed when he was going through it that the gate was open and unsecured. He met with appellant's foreperson in the trailer, and upon leaving, the gate hit him.
No, go ahead.
So obviously, appellant's foreperson was already there that day before plaintiff had gone through the gate and left it unsecured.
And there was also testimony that whoever arrived early, and it was usually Marriott, and he was proud of that fact, I mean, that was the words used, they would open the gate.
That's correct, and there's testimony from multiple deponents that state that. Unless Your Honor has any other questions, I would request that this court affirm.
Thank you.
Thank you.
Again, I would just direct Your Honor's attention to the photograph of the gate, which clearly shows that there is no locking mechanism that could be utilized to secure it to the ground. Also, the testimony from Celebi Sevic, the vice president of Ironbridge, was that Schiavone opened the gate 99% of the time. So it certainly was not the case that Robert Marriott opened the gate every day. Also, I would also like to call your attention to the case cited in my brief, Kane v. Estia Greek Restaurant Incorporated. It's a 2004 decision from this court. And in that case, the plaintiff, inebriated plaintiff, had fallen down a staircase and basically didn't know what caused him to fall. And so there's no evidence of what caused the accident. And this court stated, quote, absent an explication of facts explaining the accident, the verdict would rest on only speculation and guessing, warranting summary judgment. Here, that's all we have.
But here we know what caused the accident. We just don't know who.
Exactly. So it's going to be speculation and guessing at trial as to who opened the gate. And again, I would submit that even if Robert Marriott opened the gate, and even if he secured it or failed to secure it in the manner designed by Schiavone, that is not sufficient to impose liability on Ironbridge. Ironbridge is not the insurer of Schiavone, the general contractor's construction site. Ironbridge did not install, maintain, or repair this gate. That would be an incredibly expensive, expansive precedent. Also, with regard...
Maybe that would have been the winning argument then. Instead of about whether who caused or created this, or whether this arose out of your work, that even assuming you caused or created it, or that it arose out of your work, it was a non-actionable defect. But I don't recall that type of argument being made.
I believe that argument's made in my papers, and since I'm running out of time, I would just like to make one point. That Armental case, there was conflicting testimony as to who was negligent. Here, there's no conflicting testimony whatsoever. There's absolutely no testimony stating that Robert Marriott opened the gate on the date of loss. So we would ask that this court overturn the lower court's decision, and I would similarly echo my colleagues' sentiments on congratulations, and I'm honored to be here today.
Thank you. Thank you both. Kanayama versus Kesey.
Good afternoon. May it please the court. Jeffrey Rubenstein on behalf of the appellant from Getz, Schenker, Blee, and Wiederhorn. And first off, Your Honor, congratulations, and I echo the sentiments of everyone before me. So just to bring a few points to bear. I know Your Honors are familiar with the papers. First of all, the error within the lower court decision is simply that Kessie is a tenant and not an owner of the unit. And once that error, which is agreed upon by the parties, is bubbled to the surface, the analysis changes. And again, at that point, as an owner, they do not have a duty for the common elements within the building with regard to the negligence, trespass, and nuisance claims. And that was an error within Judge Ngoran's decision and the basis for the appeal that brings us here today. Next, a couple of things that were not explicit within my reply papers that I'd like to make explicit now. First of all, admissible evidence with regard to the Rimkus report. If you look at the Rimkus report on page 512, it's not addressed to Kessie, it's addressed to the tenant, Provence. Moreover, it's addressed to the tenant's law firm, Pillinger's office. So this idea that this is an unsworn report from Kessie is not within the record, and that is an error within the respondent's opposition to make that argument. Moreover, no one's disclosed that as an expert. So there's no one, I don't know how he has that report, but no one has formally, even Provence, has disclosed that as a 3101D expert. That's not in the record. So that's a two-pronged argument there. No one has disclosed that as an expert. And even if they had, it's certainly not Kessie's expert opinion. Again, unsigned, unsworn, and inadmissible. Next, the Shackman case, which I reference in my reply papers, as not supporting plaintiff's case. I wanted to give the proper citation for that, which is 2019 New York Slip-Op 511098. And that is listed on page 6 of my reply. And that was just an inexplicit citation on my part. Last thing I'll mention is that plaintiff tries to combine Kessie and Provence. They are separate legal entities. That's been demonstrated in the plaintiff's papers that they're separate legal entities, and there's no evidence to the contrary to that. The reason why there's no evidence to the contrary to that is that the owner, the principal, Mr. McCarthy, is passed away. So there is no testimony from him, and there never will be. So they are distinct legal entities, and there's nothing showing otherwise in the record. And on that basis, and for those reasons, I'd ask that Judge Ngoran's decision be reversed for the reasons stated within my brief before this honorable court.
Any questions? Thank you.
Thank you, Judge.